Objection to that motion right there, Your Honor. I didn't refuse counsel. They've refused me.
Them not telling you what you want to hear is not the same as being ineffective, okay?
But out of the five, two of them never even called me. I never even was aware that they were appointed to me, and they never even emailed me, called me, nothing. There was no mail, nothing. I wasn't aware that even two of those three came forward. On record, I want this noted, that they are all workers of this city, and that they do not want to help me in this matter.
Well, Mr. Bishop, quite frankly, I'm a little tired of your conspiracy theories that everybody's out to get you or force you to do things. No attorney that's ever practiced in front of me has forced an individual to accept a plea.
I have video
Nor
record.
Mr. Bishop, it's my turn to talk.
Sorry.
At least one of the motions to withdraw, there have been allegations of verbal abuse by the defendant towards their attorney.
This pro se sovereign citizen is in court today, and things do not go well for him. The entire courtroom clearly hates this guy, and they're sick of his games to get this case dismissed. I mean, this dude is on his sixth attorney, blaming everybody but himself, and acting like the legal system is some conspiracy built just to ruin his day. You can feel the tension in this one, and nobody wants to deal with him anymore. And honestly, it is not hard to see why. These antics just waste time, drain resources, and make a complete joke out of the process. Let me know in the comments what you guys think courts should really do with sovereign citizens like this. Let's go ahead and dive in and watch this clown.
Now, at this time, I am going to grant the motion to withdraw, and Ms. Ilola, if you would like to leave, you're free to go.
Thank you, Your Honor. Before I do, though, I do want to make a record. Mr. Bishop did hand me a lot of materials to look over, which I did do so for his case. I would like to hand them back to him on the record, just so that way we do not have any further issues going forward. This is everything, including the flash drives that were given to me, and then including the new motions that were addressed for this is the motion to withdraw that was sent to you also, but I wanted to give you a copy of it in person as well.
And Mr. Bishop, are you satisfied that Ms. Ilola has returned everything that you had provided to her?
I believe so, Your Honor, with a quick glance over.
Very well. Counsel?
Your Honor, I just wanted to make sure, clarify, does that include all the discovery provided by the state?
I believe so. Based off of what I was given by Mr. Bishop, I believe that's all the discovery as well.
All right. Thank you, counsel.
Thank you very much, Your Honor.
Okay, so a couple of matters that we need to address. Number one, the defendant, pro se, prior to the withdrawal of Ms. Ilola's counsel, filed a motion to enforce. That was filed on the 16th of January. In essence, the defendant is asking this court to order a different court to take legal action. This court has absolutely no authority to do that. Certainly, the defendant could seek a writ of mandamus from the Ohio Supreme Court, asking it to order the domestic relations court to proceed. But
Repeat
this,
that. I barely can hear you. I'm sorry.
well, here's the thing. This court does not have any authority to tell another court what to do. All right. So I'm going to deny your motion to enforce. Now, there are certain other steps that you can take to try to get the relief that you sought from this court. But obviously, that's something that you would have to do at this point on your own. Now, the other thing that was pending and has been pending for a while is the defendant's motion in limine regarding the use of a recording which purports to capture a conversation between the defendant and at least one, if not several individuals at the domestic relations court. The allegation being that the recording itself was made not by Mr. Bishop or the individual that he was speaking with. And in fact, the state seems to concede that fact in its memorandum contra the motion to in limine. And the court did considerable amounts of research yesterday afternoon. And here is basically what I found. Normally, a statutory violation is not remedied by exclusion. For instance, if an officer stops an individual for operating a vehicle while impaired outside of their territorial jurisdiction, that's actually a violation of law. But because it's not a constitutional violation, a defendant would have absolutely no relief or recourse to seek any type of exclusion. Now we need to address the issue of counsel, or maybe we probably should have done that first. It doesn't really matter because the last time we were here, when Mr. Iteum withdrew his counsel, the court did indicate and explain to Mr. Bishop that I would be reaching out to the Ohio Public Defender's Office to see if they would be willing to represent him. Thankfully, they were, and I explained to him that if they weren't, or if that didn't work out, that the court would very likely declare what's called a constructive waiver of counsel. So, done a little research in that regard as well. There's a case out of the 5th District, actually, from April of last year. It's in re adoption of AMV. It's 2024 Ohio 1240 is the site. But basically it talks about the fact that in that case, 2 separate attorneys were appointed to represent the defendant in a parental rights matter. The rights are conveyed under a different authority than the constitutional, but it's pretty much related. And then after the putative father basically fired both of those attorneys, the court reached out to every other attorney on that county's court-appointed list, all of whom declined to represent the putative father. And the ultimate ruling was that the defendant had 2 options at that point.